Good morning to everyone. I want to thank Judges Maldonado and Ackerman. And we had a great day yesterday, and I guess that means don't drop the ball today, everyone out there. We have a lot of people who have been here before, so I'm not going to belabor the instructions. I do want to remind everyone that we've read the briefs, we've read the applicable law, and we've had the benefit of research reports and bench memoranda prepared by our law clerks and research attorneys, which is all to say that we ask that you not simply come up and repeat your brief. What we really want to hear are a few points that you think are particularly important to stress during oral argument. And if there's a new case or a statute or regulation that's come out since you filed your brief, it would be nice to know that as well. But most importantly, if we have questions for you, this is your opportunity to address them. I do want to caution everyone, we have some cases involving victims of domestic abuse or complainants of domestic abuse and children. And please don't use any names. Everything here is being recorded and will be put on YouTube at some point. So we ask that you just refer to them as, the person or the child or by their initials. So with that, I will call the first case on our docket today. Number 15, docket number 375374, People v. Villario. Okay, clearly. I apologize. I'm not very good with names. I'll be the first to admit. Is it Mr. Hall?
It is, Your Honor.
Right, please put your name on the record and you may proceed.
Thank you, Your Honors, and good morning to all of you. My name is Matt Hall. I'm a lawyer with the Ottawa County Public Defender's Office, and I represent defendant appellant Ronaldo Villarreal. I just have three brief points I'd like to make as a part of argument here today. First, the parties agree that it's an abuse of discretion standard. I believe that in the plaintiff's brief, they use the old perversity of will, defines a judgment, and exercise of passion or bias definition. That's an old definition rejected a couple of decades ago. I believe that the defendant's decision falling outside of the range of principled outcomes definition would apply. Second, Your Honors, on page 6 of plaintiff's counterstatement of facts, plaintiff claims that once out of the vehicle, Deputy Zaragoza began asking the defendant for his identification and cites page 8 of the preliminary examination transcript for that proposition. Now, this is important because what page 8 of that transcript actually shows is that defendant Zaragoza did not ask defendant for his name until after he placed the defendant into handcuffs. So that factual issue is important because in pages 12 and 13 of the plaintiff's brief, plaintiff argues that there was sufficient evidence that criminal activity was afoot based in part on the defendant's continued refusal to identify himself, defendant's provision of a wrong birth date, defendant's provision of a wrong name, defendant generally changing details and not being forthcoming about his identity. However, all of that happened after he had been put in handcuffs, put into the squad car. And so that's just circular reasoning in this case. You can't use post taking into custody conduct to justify taking somebody into custody. So I think that's an important factual issue that I'd clarify. Finally, both the plaintiff and circuit court believe that this case is analogous to People v. Quinn, 305 Mishap 484 from 2014. However, I know that this court only took up the facts in Quinn on an appeal from a denied motion for directed verdict. So by the time this court is looking at Quinn, it has to view the facts in the light most favorable to the prosecution in that case. So that's a procedural distinction between where we are right now. In addition, the Quinn case involved two individuals at 1 a.m. walking quickly away from a police officer into an apartment building and then admitting to the officer that they did not live there. That's a huge red flag. And that type of red flag, President Quinn just is not present in the facts of this case. So as argued in my brief, Deputy Zaragoza's order that defendant identify himself was just not a lawful order in this case. And so for that reason, this court should reverse the circuit court and quash the bind over in this matter. And with that, unless there's any other questions, I would just reserve a couple minutes for rebuttal.
Okay, you'll have those.
Thank you.
Thank you.
Good morning and may it please the court. Luke Staney on behalf of Ottawa County. At this time, your honors, I'm prepared to rest on the brief submitted, but I would welcome any questions that the court may have.
No, thank you.
No, thank you.
Thank you.
I'm not sure how you can provide rebuttal to resting on your brief.
Your honors, I barely had a chance to pour a sip of water. That's fine. I'd rest on my briefs. Thank you.
Thank
Thank
you.
you.
We appreciate
Have a good
it.
day.
That case is submitted. Calling the next matter on our docket, the 16th matter, docket number, 376568, People v. Araza.
Morning, Your Honors. May it
Morning.
please the court. John Zebelking on behalf of Ms. Joy Arousa. And Your Honors, we're here because Officer Zager pulled over Ms. Arousa on 28th Street here in Kent County without reasonable suspicion of a violation of law. And that's what we asked the court to find, of course. Now, the prosecution has offered evolving justifications for this stop, including that Officer Zager testified Ms. Arousa was driving with a continuing turn signal. She wasn't making a turn. And the officer believed that that was a violation of the motor vehicle code. It's not. And the officer later admitted his mistake of law about that. Officer also stated that she was speeding, but the officer was incorrect about the speed limit on 28th Street, and Ms. Arousa was not speeding, and the court ultimately so found that. So those preliminary justifications did not justify the traffic stop. But at the evidentiary hearing, the prosecution offered a new theory, and that is that Ms. Arousa had violated the general safety principles that are implied by MCL 257.602. And I think it might behoove us to just read that here. I have it here, Your Honor, if I may.
Please.
A person shall not refuse to comply with a lawful order or direction of a police officer when that officer, for public interest and safety, is guiding, directing, controlling, or regulating traffic on the highways of this state.
As I recall correctly, there was no order or signal by a police officer that the defendant violated here, correct?
That's correct.
All right.
Yeah, Officer Zager was not controlling traffic. Ms. Arousa did not violate or refuse to comply with any lawful order.
And as soon as the signal was put on, within a reasonable amount of time, she pulled over into the parking lot.
That's
correct?
my understanding, Your Honor, and that's never been a point of contention here in this case. So I believe that to be so.
Okay.
Yes. But the trial court did find that that was a reasonable justification. And it stated at page 50 of the evidentiary hearing, it stated MCL 257.602 includes the larger public safety implications raised by a vehicle traveling in these circumstances on a large commercial street. Of course, the circumstances are she's driving with an ongoing turn signal. She's not making a turn. So here we have general principles of public safety. The motor vehicle code is extensive, it's comprehensive, it's detailed, it embodies public safety on our streets. That's where we find that rule, not in some generalized principle,
Well, and if we were to read that provision the same way the trial court judge did, wouldn't that mean that that provision applies basically to every movement on a public street?
It opens that door, Your Honor. And even if it just applied to someone with a turn signal, it's so common that people, I took driver's training back in the dinosaur era. And even then, as we were driving the Flintstones cars, even then, they told us, do not trust the turn signal. And that's in our psyche as drivers, at least around here. And that's what we all do, is we wait to see that car turn.
I'd say that is dangerous, though, to have a turn signal on as you go straight through intersections from the right lane. Someone thinks that this is an opportunity to turn right on red and then gets T-boned and probably the most dangerous part of a vehicle. So I think that I would understand why a police officer would see it and maybe subconsciously have suspicion of drunk driving or other concerns. And you combine that with the fact that this person pulled so close to the officer's car in a place that had 2 lanes that the officer felt as though they had to change lanes, regardless of the speed limit, whether they were going the speed limit. That's concerning. And the video we saw, I thought there was some drifting within the lane from the far left to the far right. It wasn't a swerve, but it was subtle movement. I thought that, perhaps those in combination could provide basis for reasonable suspicion of drunk driving. Would you say that, could that be a basis if that's not what the officer said in court, if an objective observer could see that evidence and reach that conclusion?
And the court grounded that part of its decision about the possibility of operating while impaired, grounded that on Christie. And in Christie, that was one of the circumstances the officers pushed to. I'm sure you're speaking to that as well, because you said it was absolute swerving or what have you there, right?
It was a drift, but you can see that right before the defendant got it pulled over, like almost hit the far left lane and then kind of may have even gone over the line on the right. I mean, I did see it drift slowly.
And that was at the time that it was being pulled over.
Yeah, I mean,
And that
It was
can happen
it was
just as a
immediately
reaction.
before, that was
Immediately
immediately
before.
before the officer,
Immediately before the officer. did
immediately
that.
before the
Okay,
officer
immediately
turned
before
his
the
light
officer
light
did
on,
that.
yeah.
So there was some movement in the lane. Didn't amount to swerving.
I even have a.
I thought
Yeah,
it was
okay.
pretty minimal myself, but.
What's
you
that?
know.
Yeah.
I said, I thought it was pretty minimal myself, though.
Yeah.
God
I-
forbid we ever look at the little display on our
yeah,
computer in
a
our
little
car
bit.
and all of a
Yeah, so
sudden
it says,
turn a little
"Oh."
bit.
Yeah,
The
exactly,
police
right?
officers of Grand Rapids will,
Yeah.
Would the fact that the officer pulled her over, justifying it on a different basis matter?
No, ultimately not. Of course not. No, this court can find that it was justified on
Yeah.
a different grounds. Absolutely, it could. We urge the court not to do so, but we would certainly agree that alternate grounds could be found.
Well, what about the fact that her expert testified that she was actually speeding? It wasn't 25 miles an hour, it was 25.8, right?
It was, so the speed limit there was 45.
I'm sorry, 45, yeah,
And she
yeah.
wasn't doing 46. But I guess there would be a 0.8. I guess that could be possible. The trial court found, as a matter of fact, she was not speeding, but again, that would be a possible justification if we're searching for reasons to pull over a person who has an ongoing tail light. That's what we're looking at here. That's the real crux of
The
this whole thing.
blinker, the
The
blinker.
blinker,
Yeah,
yeah, the ongoing turn signal, I should say, right?
Turn signal, right.
And again, we have a statute that covers that, MCO 257.648. Says you have to turn on a turn signal before you turn, gives detailed instructions.
Just because it instructs you to put on a turn signal in certain situations and she wasn't turning doesn't mean that it's okay to, it may not be a violation, but it is a signal of causing some hazard to the road. As I was saying, like someone, it's pretty easy for someone to pull out, get T-boned.
So now
And
we
that's
have-
exactly like the sort of reason we want to pull people over for reasonable suspicion of drunk driving is because in this situation, someone's drifting, pulling right up to a police car, and then has their turn signal on going through multiple intersections. I just think there is a public safety concern. It may not in and of itself be a violation, but I think it is something that would strike me as concerning.
Yeah, I understand that. But in fact, it's not in the motor vehicle code. And what we're essentially
And
doing.
if I recall correctly, this was not, I mean, if we're going to look at something that doesn't violate the law, that could potentially cause, create a risk of danger, we're basically looking at the context. And if this was out on some country road where there wasn't another car in sight for miles, then it really doesn't increase the risk at all. Similarly, if it was at a time of day that there was literally no one else on the street, then I don't know that it really increases the risk at all. And if I recall correctly, did this happen at like 11 at night or
11:30.
11:30?
Yep, I believe it
Was
a Sunday
there,
night.
so on the video, is there any indication
No.
of any car?
No.
No,
Right,
no, it's
so
not.
if we're looking at the context of whether there's an increased risk, I guess I just don't see it here, but maybe this is something that the prosecutor can
Yeah, but
address.
on the other hand, essentially we'll be writing into the statute 648 that you have to turn when your turn signal is on at the next available opportunity.
But that's
and
for the
that-
legislature,
Thank you.
correct?
That's for the legislature.
I think it also depends on context. So if you're on the freeway and your turn signal doesn't you turn right in an intersection, it typically will turn off, or you're at least more conscious of it because there are other cars, and there are cars being passed at these intersections. If you're on a freeway and you put your turn signal on, the hazard is that someone slows down thinking you're going to switch to their lane. It's not that you T-bone someone. So I think that you should be more conscious about having a turn signal on if you're on the right lane crossing straight through intersections than if you're on the freeway in the middle lane and someone just thinks that you're trying to merge to reach the next exit and slow down. I mean, the hazards are different. And I think that all of those are just factors towards reasonable suspicion of drunk driving. It doesn't need
So
to,
we're going to the drunk driving aspect.
I think that's the one that concerns me the most. Or an expert saying, the reconstruction expert finding 0.8 miles per hour over the speed limit is a violation. Right?
Again, she's not doing 46. She's within the 45 miles an hour. She's within 45 miles an hour. So and again, the trial court found, as a matter of fact, you could go back and find clear error in that, but I would urge the court not to do so. And again, that minimal amount that she might have been over, again, that could justify a stop. That's possible. Yeah, that's possible.
Yeah.
But under these circumstances, I'm sorry, go ahead, George.
No,
please.
I thought you were wrapping up there. I apologize. I jumped in.
I can wrap up anytime.
I can go back and look at the video again. I've looked at it many, many times, but can you remind me, because I was listening to what Judge Ackerman was saying. Can you remind me? I don't remember. Do we see on the video them going through intersections?
There is an intersection that has gone
Okay.
through. Yes, correct. Yeah.
Okay.
Mhm, yes, there is. But again, I would just urge this court, again, we put this into one. I'm driving, I plan to turn here at a store up the way, I pass a driveway, an officer can pull me over now. If we come to this ruling, if this stands. And when we put it into vague principles of public safety, and I'm sorry, I understand there are some things in our laws that are left open.
Well,
And
that
here-
statute, I mean, that statute is directed to following a police officer's order or signal. And there's no police officer order or signal. I mean, I just don't see how that
It's a sub-
statute can be read that way.
And it's a subordinate clause in that statute, Your Honor, even more so. So there's there's only this kind of vague principle of when we might believe that public safety is at risk.
That
Due
would,
to a
that would
burglary.
allow a police officer to pull someone over almost under any context.
Exactly. It would expand the number of invasions into the privacy of citizens driving on the
And
street.
if the person was looking to her right for, a second, then a police officer could say, well, she's not paying attention to the road. I need to pull her over.
This vague principle of public safety should not be applied here when we have the motor vehicle code. And we would essentially, yeah.
Why don't we hear from the other side?
Thank you very much.
And then you'll have time for rebuttal.
Thank you.
Thank you.
Thank you.
You're giving me so much to think about.
Good morning, Your Honors. Amanda
Morning.
Ingram on behalf of Plaintiff Appellee, the people of the state of Michigan, through the Kent County Prosecutor's Office. Just a couple points to touch on. First, the overall standard that we need to always come back to when we're talking about a seizure, including a traffic stop, is reasonableness. And that's an objective reasonableness, given the totality of the circumstances. We know this. going to, the mistake of law. It has been held by our our United States Supreme Court in Hyen versus North Carolina that, it says the question here is whether reasonable suspicion can rest on a mistaken understanding of the scope of a legal prohibition. We hold that it can. And in this case, young officer thinking that that particular statute also means, regarding the turn signal, that also means that, you can't just leave it on forever. In my mind, I would have maybe thought so too. I would argue that is.
It's understandable why he made the mistake of law. I mean, again, you indicated that he was pretty young. I also point out that he didn't even know what the speed limit was, and it's entirely possible that he was driving under the posted speed limit because the only evidence we have in the record is that she was going 45.8. You, in footnote 1 of your brief, you disclaim any reliance on speeding. Is that fair?
That is fair.
Okay, so we're not going to look at speeding because there's really no evidence that she was speeding. Is there any evidence that she accelerated or deaccelerated in any kind of unsafe or rapid form?
Not that I'm aware of.
Did you make the argument that she swerved or drifted in an unsafe way?
I did not make that argument, correct.
What do we have? So we have that she had a turn signal on. What about, I think opposing counsel made the argument about that, and I forget the MCL, but it's the statute that's directed at a police officer's order or signal.
MCL 257.602.
How does that fit here? I mean, you heard our responses to that a moment ago, or at least my response to that. I just don't see how that fits here.
And Your Honors, in my brief, I did state, first of all, that MCL 257.602 does put the burden on the person being directed. It is not, I agree, it is not the officer's, the action portion of this says you must stop, you, not the officer, you, the person being directed by
Right,
the officer.
and so
it doesn't.
are you
I agree.
agreeing with opposing counsel that there's nothing in the record to suggest that she didn't follow the order to pull over when the signal came on within a reasonable amount of, a few
Correct.
seconds?
I agree that that was not ever implicated. My point with agreeing with the trial counsel, the trial APA in this case, who raised that potential issue, is that what it does is it does implicate this broader public safety concern and how our officers, especially our road patrol officers, are out there tasked with making sure people are driving in safe manners. Yes, this is addressed through statutes. And yes, maybe this young officer had a mistake of fact on this one particular statute, or even if it was speeding, a mistake of fact. But as I make very clear in my brief, also, it's not just the turn signal, it being on.
What else is it?
It is the turn signal that gives rise to other potential suspicion that something else is going on. And
So in your mind, or I don't mean your mind, your argument, it's purely a turn signal that's left on longer than what we would say is a reasonable amount of time. That alone is going to be cause to pull someone over for suspected impaired driving.
Yes. At
Okay, so
111
to Judge Ackerman's hypothetical about someone on the highway is in the middle lane, if they leave their turn signal on for, let's just say 15 seconds, that alone, not speeding, not swerving, not doing, not looking around or anything, that alone is going to be enough for a police officer to pull someone over for suspected impaired driving?
In context, yes, I agree.
Because literally that would mean, I don't mean to throw myself under the bus, but I have left my turn signal on for an embarrassingly long amount of time. And you're telling me that alone is going to give the trooper behind me cause to say, we need to check to see whether this person's impaired?
It could give my argument is that it could give that officer or trooper reasonable suspicion to believe that any number of things is going on. Either this driver, and not that I'm saying they should pull over every time, somebody every time for a blinker, because I certainly have done it as well. And I'm always pointing and giggling at somebody else who does it, because it's more a nuisance in my mind sometimes, but in context, as Judge Ackerman said.
I think my point was the opposite.
Oh, well.
I thought it may not be as bad on a freeway.
Right, that's what I'm
Right.
saying.
No, but I may
So,
giggle
I
about
guess-
it is
I
what
guess it
I'm
depends on-
saying.
Yeah,
But in a freeway, it still could mean they might be impaired. So that question is going off in my head. So they might not just be paying attention. They might be driving distracted. Are they looking at their phone? They might have malfunctioning equipment, which is, both distracted driving and driving with malfunctioning equipment are violations. So I mean, if this,
The traffic code has so many rules that I think I read somewhere that, if you follow someone for 3 minutes, you can find.
you're going to find a violation.
You're going to find a violation
Yes.
because it's just so rule laden. So why do we need to open this up like this here? And especially when the officer could have just followed her for 3 minutes.
Well, let's consider the opposite. What happens if we don't and the person eventually ends up in a crash?
But that's,
Yeah.
those are type 1 versus type 2 errors. We face that as a society every day of the week. And we have to draw a line. And we do, we could literally just we could have checkpoints at every mile. And I can guarantee you that will increase safety, but it would also destroy liberty. And so we draw those lines.
Mhm.
And here, I will readily, I readily understand that a turn signal left on for an unreasonable amount of time is one piece of evidence that might go into the reasonableness calculus. It's certainly not something to ignore. It's a little odd. But my question to you is that alone going to be sufficient for a police officer to suspect impaired driving and pull someone over at any time when they have that turn signal on for, let's just say, 30 seconds?
As you stated earlier, I would say, given the context, and in the interest of public safety, yes.
Okay, so to Judge Ackerman's point, if you're on the highway and seem to be driving perfectly fine, but you've left this turn signal on for 30 seconds, that's sufficient alone for pulling over for impaired driving. Same as on 28th Street at 11:30 at night. Same, doesn't matter where we're at. A turn signal left on for 30 seconds is now sufficient cause, it's reasonable suspicion of impaired driving.
I would not agree because the context does matter.
Okay, so.
And that
what if-
is another part of that suspicion.
Okay. But again, going back to Judge Ackerman's example or hypothetical, what you're driving in the middle lane of a highway, 30 seconds, your turn signal's been on, you're driving straight down the middle, no swerving, just the perfect driver. Maybe your Tesla's taking over the wheel or something. But you said a few minutes ago that would alone be sufficient. So what's the context there that adds to the impairment suspicion?
The impairment suspicion, like I said, it's not necessarily going to be suspicion of impairment every time. Suspicion of maybe another rule. Yes, and I've never driven a Tesla because my government employee salary certainly can't support that. But
Pretty fast, I can tell you that. I don't
I
have one, but
have understood that they're pretty
I've driven
fast.
one and ridden in one. They're quick.
I've heard they're pretty powerful too, and they have some good pickup. But again, I would argue even then, it could be that, even maybe in the officer's mind, again, these other potential issues are
Yeah,
going on.
but we're past the officer's mind. I mean, that's a subjective analysis. We're
Mhm.
looking at, the
The
objective.
objective, correct.
And you seem to be trying to have it both ways. That a turn signal alone would be sufficient, but within context. Well, the context,
Well-
I would argue, is another indicia that you could look at. But again, to go back to Judge Ackerman's hypothetical, what in the highway, on the highway? Because if we agree with you, there's at least going to be unpublished, maybe published, we don't know, case law saying turn signal alone sufficient to pull over. And I can guarantee you, police officers are going to start looking at this and saying, awesome. And so what boundaries can we put on this that you would say, okay, a turn signal alone is not sufficient? Are there any boundaries we can put in this?
Again, when I was going into the context aspect, that was specifically regarding, I would say that the impaired driving, which happened to be what this officer was thinking. And in the context of 28th Street, passing through intersections and passing by driveways, yes, it is hard because, now, like I said, and I've argued that, yes, I would agree it is reasonable suspicion that something else is going on too, and which would be a violation. On the freeway, is it as much a violation of impaired driving? Maybe not if they're not swerving or anything else.
So is it the turn signal plus, let's just say more than a half dozen opportunities to turn? That's enough. So if there's 6 opportunities to turn right that are passed, those two pieces of information put together, that's enough?
We're starting to get very nitpicky, obviously, but it's, yes, it's obviously showing that officer that this driver is not paying attention. Again, whether it be impaired or because of some other reason, we don't necessarily know. But we also would just argue in general that, again, public safety officers are just that, making sure that the roads are safe, that people are driving in a safe manner. And by tying their arms I know, yes, we want to have a good basis for reasonable and articulable suspicion as well. But here it was articulable, for
When
this
we look at the
officer.
video, will we find that she endangered any other driver or pedestrian?
It is my understanding that there were not many other cars at this particular moment.
Many or any?
I will admit on, Your Honors, I went strictly by the testimony. I did not watch the video.
Okay. Anything else?
No, Your Honors.
Any other questions?
No, thank you.
Any other hypotheticals, Judge Ackerman?
No other hypotheticals. I think that Tesla full self-driving wouldn't leave a turn signal on though.
Elon has already thought of that problem.
Probably.
Thank you.
Thank you.
If I may, Your Honor.
Please.
I learned a lot about Teslas today. Your Honors, first and foremost, whatever this court holds, I would urge this court not to hold that a turn signal, ongoing turn signal while driving straight alone justifies reasonable suspicion of impaired driving. There are so many innocent explanations for why a person would have a turn signal on, such as some hearing loss, as I am familiar with a bit, such as being, preoccupied, distracted driving, looking at a phone. That's one thing. We're always semi-distracted. I'm a guy who focuses on the road. I focus on the road. I learned it early. I do that. But I still leave my turn signal on.
Here, wouldn't there be that it's not just the turn signal, it's pulling up so close to a police car that they won't feel they need to switch lanes. It's going through intersections. It's in the evening where there's probably more likely to be a drunk driver on the road. And wouldn't you want a police car to pull this person over now rather than when they do get to that intersection where there's that car turning right?
No, because there's no reasonable suspicion of a violation of law. And again, there's some open areas in our law. It's in the code. But, I would say my only point there was not on the basis of the turn signal alone. That would be just a bridge too far in the liberties of the citizens driving the streets and highways of this state. Second, I believe the opposing counsel was addressing the exclusionary rule about the mistake of law. I would just direct this court to the brief on Shabazz and that element of, to Lusinski. Pull that up here as I go off track. Sorry, Your Honors. I left that at the table. Anyway, Lusinski, and that's in the brief. as to a reasonable mistake of law and whether or not this was one, which it was not.
Okay.
And then also, of all the things that could be going on, again, so many innocent explanations, so common, happens all the time that people are going with the turn signal. I don't see where you can apply that alone means, oh, that she's driving impaired. And if this were in a statute, which it's not, it would have boundaries. It would tell us, here's the distance. Here's what you can do, because that's the way the traffic code is. That's the way the vehicle code is. It would give us boundaries. It's not in the code. It doesn't give us the boundaries that we're seeking here. And then finally, I believe there was a mention of malfunction in the vehicle, and I searched around for where that might be in the statutes, and I did find one. It's 257-697. And it says when a vehicle is equipped with a stop lamp or other signal lamps, the lamps or the lamp or lamps shall at all times be maintained in good working condition. Well, the signal was in real good working condition.
Yeah.
So I don't see where that is going to apply either. And of course, Ms. Arouse asked this court to reverse and remand with an order to grant the motion to suppress.
Okay.
Any further questions, Your Honor?
Any other questions?
No, thank you.
Thank
It's
you
very
very much.
interesting case.
Thank you.
Thank you.
As you can tell, this was an interesting case that we've all thought about. So thank you for briefing it and arguing. It's been very helpful. Thank you.
And can I just mention that I hate interesting cases?
Fair enough. Fair enough. That case is submitted. Calling the 17th matter on our docket this month, docket number 374485, People v. Slough.
Good morning, Your Honors.
Morning.
Christopher Tholen, Charlevoix County Prosecutor on behalf of the people of the state of Michigan, the appellant.
This was another interesting case.
I think so as well, and I'm glad you feel the same way because I did come down here for the specific reason that I'm hoping you'll ask me questions. I think it's an important case and an interesting case.
So I have a question. I mean, I know you have things to say and you'll have an opportunity to say those,
Thank you.
but you open the door with hoping that we had questions, and we do.
I am. I've argued several times in the Court of Appeals, and sometimes when there's no questions asked, you just leave and think, what did I come here for?
What, so Officer Byrd got the search warrant.
He
He
did.
filled, he was the, filled out the affidavit in that, but he didn't testify at the motion to suppress hearing. Why was that? That seems odd, given the fact that he seemed to be kind of the main person in charge of this, and there was a choice not to call him as a witness.
I can give three reasons, but ultimately it's somewhat speculation. The first is he had testified at the preliminary exam.
Okay.
And the preliminary exam transcript was admitted as an exhibit at the motion to suppress. So the judge did have his testimony on it, which had come up during the preliminary examination. So that's the first reason. The second reason, I'm not sure if he was unavailable. So Detective Wheat did testify. I'm sorry, I did have a third reason, but ultimately it's purely speculation. I don't know. Oh, the third reason, the assistant prosecutor who had handled the hearing really hung his hat on one issue. And unfortunately, because of that, there wasn't as much of a record made of really all the issues that I think are important for this court on appeal. But ultimately, he was hanging his issue solely on the standing issue, that at this stage, the defendant was being allowed to vicariously assert the Fourth Amendment rights of his neighbor. And that's really where he was hanging his hat at the hearing. And so that was the focus of the testimony that he presented. I don't know for certain whether that was why Detective Byrd was not called, but that would be my speculation, is that he was not called for that.
What about the other thing that at least struck my thinking on this was when you look at the video, and I think there were some stills of the video, or at least I saw a still of the video, it looked like there were a number of mailboxes that were visible from the road.
Three.
In the still?
Well, it might have been a video and I may have just seen a screenshot of it. So it's in the video.
Okay.
And I know this was at night that the warrant was executed,
It's
but,
from the body cam, though.
okay.
Yeah.
So these mailboxes were fairly clearly visible. Wouldn't that have caused someone, a reasonable police officer, to raise a red flag and say, there may be more than one person back there, or this may be more than one person's property, given the fact that I don't know that I've ever seen one person have multiple mailboxes. I'm not saying it doesn't.
Yeah.
But that would at least strike someone as, oh, wait a minute, there may be a bunch of people back there.
It could. And what I would say in response to that is, first, there were photographs admitted by the defense at the hearing on the motion to suppress. Those mailboxes show 4. There's 4 in conjunction. So no matter what take you make of it, there's at least one other residence who is sharing this mailbox post.
Okay.
So
but
but
that's
your
not-
point remains.
That's not my point. I mean, who knows who's sharing or splitting up? You see multiple mailboxes, and to a reasonable police officer, that should have suggested there's more than one residence back there.
More than one residence in the vicinity is what I would say. And
Was there any other trailers in the vicinity? I mean, vicinity saying, a 1/10 of a mile?
there must be. There must be a residence that's also sharing that box.
Is there
because
anything in the record?
There is the photograph that the defense admitted, which has 4 mailboxes sharing a post.
I thought there were 3 trailers there,
There were.
and the defendant's trailer was very distinctive. It was a distinctive color, and it was the only one that had a standalone garage. Am I remembering that correctly?
Detached, yes.
Yeah.
So
I mean, that could have been like, if I were drawing up the search warrant, I would have said, tan house with detached garage.
yes. I guess I'll answer that right now before I come back to what I
Feel
think.
free, you're getting thrown
Um,
all kinds of things at you. so
Which I
just
appreciate.
Do your best.
That's
Well,
why I'm here.
you wanted questions.
Yes, so that would be something they should include if they could see it. And that's a big part of this case, is what they were actually able to see given the situation and the circumstances of this. As the search warrant says, or the affidavit says, the search warrant says, this is actually a very difficult, specific chunk of property to see. It's obscured by trees from the road. It's a significant distance off the road. On the body cam, it takes them 2 minutes to walk back.
How did Byrd get the information to fill out the affidavit? Did he explain that during the prelim?
The road.
So he was standing at the road and he was able to kind of look back along the driveway and notice a few trailers?
Yes, he described it as 2 trailers, brown and white, obscured by pines.
Okay, so if he was standing on the road earlier in that day or day before or whatever, to gather the information for his affidavit, he would have noticed the mailboxes for sure. And that wouldn't have raised a red flag in his head to say, these might not all be one residence. There may be multiple residences, and I should probably figure that out before filling out this affidavit.
That would be one thing he could do, but even if he did that, he doesn't figure out where this 4th one is. No matter what,
You
there's.
keep bringing up the 4th one. I'll be honest, I don't care about the 4th one. Maybe it's a house, maybe it's a trailer or house, a 1/4 mile away, fine, okay. Or maybe it's across the street, behind him. But there was at least 2 trailers that he saw and 4 mailboxes, 3 or 4 mailboxes. How does that not raise a legitimate question to a reasonable officer to say, there may be more than one residence back there? Because if I recall correctly, this affidavit simply assumed this is one residence. It's all owned by the defendant, and doesn't matter if it's a compound with 2 or 3 trailers, it's all him. But the multiple mailboxes, I think, raise a legitimate question of maybe it's not all him.
So I will go back to vicariously asserting someone else's rights, because what the affidavit has is that the defendant's address is 15340.
But see, I don't think that is vicariously asserting somebody else's rights. I think it's evidence that the face of the warrant was so deficient that the officers actually went to somebody else's house. Like we get to watch them. It could have gone really badly, go into a completely unrelated person's trailer. And you know, that to me is what it actually signifies. It's not that you're asserting their rights. It goes back to whether or not that was a sloppy, insufficient warrant.
They listed 15340, which is the defendant's address, and that's where the evidence was obtained. So if you look at the cases, which I've cited, we've got Garrison from the U.S. Supreme Court, Alls, Foster, and Moore out of this court, Foster being the only one published. All of them dealt with that same situation where there was some indicia, whether it was numerals on a door, I think that was Moore and Foster, the numerals on an apartment, separate meters I think that was Foster, or separate doors in the U.S. Supreme Court, Garrison. In all of those cases, there was some type of indicia. And what this court said in Alls is that to any extent that officers were required to discontinue their search upon realizing there were multiple units, quote, it was only with respect to the other apartment. They could continue their search limited to the apartment of the person identified in the warrant, defendant. So in this case, if they knew, which the evidence is not that they knew, the evidence is that they could have been clued in from the mailboxes. The evidence is that they didn't know, and that would then only tell them, don't search 15336 or 15338 and just go to 15340, which is the defendant's. What the body cam and the pictures, the daytime pictures show is the defendant's is not, it doesn't have numerals. And the numerals on 15336 are very obscured. So there may be these separate mailboxes, or there are these separate mailboxes. I won't dispute that. But even then they go down this driveway, how are they supposed to actually figure out which is 15340?
Well, that's kind of the point. I mean, they decided to execute this at night, as I recall. That was a choice on their part. And I get, you know, there's good reasons to do that from a police enforcement. But if you choose to do it at night, you have to take the location as it is. And so the fact that it was dark isn't really the defendant's fault. It was the decision of the police officers to execute the search warrant at that time of day. And the affidavit was vague enough that the police officers did in fact go to the wrong trailer, correct? I mean, the first one that they went into was the wrong trailer, correct?
Yes.
Okay.
Yes.
And to Judge Maldonado's point, it's just luck that something horrible didn't happen. Either a police officer get injured or worse, or the resident get injured or worse. I mean, that's one of the reasons why we require some specificity in these affidavits.
Yeah.
I mean, there were two people in that trailer, and if you remember from the video, the one person had to like calm the other person down and get them to comply. Like, I was worried about what I was about to watch.
So the warrant didn't lack specificity, though. It's just the circumstances of this parcel made it difficult. The warrant was specific, 15340. So the warrant was specific, and that's where they found this evidence, is 15340. The issue arose because there's multiple, there's a lot of property on this parcel. And it's
When you
not,
say property, are you talking about like trailers and residences or real estate? I don't know what you mean by property on
thank
the
you.
property.
There's a lot of slabs of wood, vacuum cleaners, tarps, fencing of various heights, vehicles, things of very unknown character, just a lot of
A lot of
trash.
personal property strewn about.
Yes, and
Okay.
a detached garage that does not appear to be functional as an attached garage, but could look like another domicile or structure capable of habitation. There's a lot of stuff
But
down
doesn't
this
that-
shared driveway.
But doesn't that make it all the more important to have more info? I mean, you didn't have a warrant to go in and search for a bomb or guns. You were looking for crayons, pens, and paper. Like, so don't you think it might have been safer for the community to get a little bit more information so that you could make sure that when you have all these different aspects, you're going the right place?
I would say if they could, they would have. But really, what more could they have done? And the circuit court stated that in the opinion of it, minimal investigative effort would have done more. But I push back on that in my brief and in my argument to you today, because I don't know what that is. If they needed to use a drone to get so close that they could determine addresses, for example, so that they could determine, okay, it is this specific brown and white trailer that is 15340, they have to get that drone very close.
Well, I don't know that we are at the point of our society that we're requiring drones in these circumstances, but it might actually call for executing the search warrant during the day rather than at night. Because if in fact, I take you at your word that there was real or personal property kind of strewn about. I mean, this was very dangerous for everyone involved to be executing this search warrant at this time of night. And again, you indicate, I mean, fine, the affidavit was specific, but it wasn't specific enough in terms of description of the property, because it did lead these police officers to the wrong trailer.
A couple of points.
Yeah.
The body cam does show the property that's sort of everywhere. So that's not just, merely. It does show that. And the search warrant disclosed to the magistrate the difficulty they had in describing it more specifically. It's set back off the road and there are pines. So the search warrant, the magistrate's eyes were fully opened to the fact that the officers couldn't get more detail in this. And I do want to stress that I don't know what more they could have reasonably done. A drone would require the search warrant in itself to get so close. They can't just drive down this very long driveway without cluing him in that, oh, the police are here. But so when looking at whether it was good enough or whether they could have done more, Maryland versus Garrison, that's the U.S. Supreme Court case, said we must judge the constitutionality of their conduct in light of the information available to them at the time they acted. These items of evidence that emerge after the warrant is issued have no bearing on whether or not a warrant was validly issued. So the discovery of multiple trailers down there has no bearing on the magistrate's decision. And that magistrate's eyes were fully opened to the fact that they had some difficulty here. They didn't hide that fact from the magistrate. And I think that goes not just to the deference the magistrate's decision is due, but also to whether a reasonable officer could have acted in reliance on that warrant. And that gets to the heart of why this is something we're appealing, because it's a crime, but it's also just that they've been told they acted in bad faith when they got a warrant. They disclosed their difficulty to the magistrate, and then they searched the actual address on the warrant. And yes, they did search another address.
Oh, wait a minute. Let's start at the beginning here. We're here because he created a pamphlet, right? Giving education about jury nullification, and put it on what I understand from the record to be a table for the public to put pamphlets, correct? That's the alleged crime that we're talking. Is that actually a crime? Does it matter that it's a crime, or it may or may not be a crime?
I would say first, that case or controversy is not before the court. The district court did deny it.
I guess we're just
In the
asking,
circuit.
just intellectually curious. You say that case or controversy is not before us. Is it even a case or controversy? That's the question. I mean, when you start reading this, you're like, I'm a little surprised that putting a pamphlet on a communal table in a public building is a crime. I could see if you're handing it to the jurors as they're coming in and out, that, okay. But
Drawn in crayon.
I will engage with the intellectual side of this, and I'm happy to, and I enjoy
you
it.
came down, we're
But-
giving you questions.
But I don't want to, unfairly only give my position on it if it's something that matters, because he may have a different response. But
Who's he?
Mr. Slough.
Okay.
There's a sole entrance, and the affidavit does disclose that there's a sole entrance to the courthouse building,
Okay.
and there's a table that's right there. It's not really a pamphlet table. It's more like just a place to sit. And so that's where the jurors were coming in during this multiple day trial. It was a drug case, which, as the court is likely attuned to, people have changing beliefs on the importance of drug cases. So there was a pamphlet letting them know there is no victim in a drug case. The state cannot prosecute if there's no victim.
Okay,
And that was
this
the nature of it.
to your point, it was right where the jurors would have to walk by.
Yeah.
And frankly, maybe being written in crayon would alert their eyes more than if it was just a regular typed up pamphlet.
Yes, and I did cite the case. It's People versus Wood. I was going to try to find the page in my brief. There is factual support that this is not First Amendment protected speech.
Okay.
That attempting to influence a juror is not protected speach. Michigan
Did-
laws,
Did the prosecutor's office bring a charge based on jury tampering?
we did not.
Okay.
Once
So
the
the police went to search for jury tampering evidence.
And you found every single thing that you were looking for on the warrant too, right?
I would say so, yeah.
But you didn't prosecute.
We didn't. We have more serious charges. He was charged with
With
second offense felony
firearms.
firearm. That's a mandatory 5-year minimum. Attempting to influence a juror, I think, is a 1-year misdemeanor.
Okay.
We did not charge that offense. You are correct. But we had a 5-year mandatory minimum charge on, as you can tell, this is habitual fourth. This is felon in possession. There are more serious things at play. So if that is something that I think is informing your thinking on whether we think it was a crime, I would just ask you to focus that we did charge some very serious offenses here.
Right. Again, you came down, it was an intellectually interesting question,
Yeah.
but from what I can tell, the merits of whether this is jury tampering isn't really before us, but it's just interesting. I
Yes,
know you
I'm
had-
sorry. I'll get you.
Judge
Sorry. to get you.
Ackerman, you had a question, I
But
think.
there's a whole nother aspect of this that also makes me wonder whether the warrant had an issue, and it's we're looking for evidence of jury tampering relating to drawing with crayon and paper. And this allows you to search any and all contents of a cell phone and electronic computer, and you keep your whole life in phone. And I just wondered how is this cabined or tailored to find the evidence and not overbroad even on its face with respect to the electronic part of this search. We've had some case law recently that
Yep.
you have to be much more narrow than any and all contents of a cell phone.
Yeah, Carson is a big deal. For,
Yeah.
just the ground level folks around the state. Somebody here authored it. It's a big deal, and it has completely changed how we do things. This search warrant, first response would be this search warrant was 3 months before Carson was released. That's when search warrant was drafted and executed. Was 3 months before Carson was released.
And Carson just did, kind of describe the law, wouldn't it? It's not a retroactive issue. It's just declaring what Fourth Amendment
Yeah.
holds, right? So
But the reason I
guess
say that
maybe on its face for whether good faith exception, perhaps, but
yes, and that's where I would urge you to look is Carson was not only 3 months after this, but Carson was then subsequently appealed to the Supreme Court, which I believe affirmed the holding on the search warrant, but reversed on good faith. Because as I was sort of saying, Carson was a big change for everybody around the state. And maybe it shouldn't have been. Maybe that's the way it should have been all along because it was restating Fourth Amendment principles. But it totally changed search warrant affidavits around the state. And we think we're complying with Carson now. And I don't think it's become extremely difficult. I think we're complying, but there haven't been subsequent cases to Carson now, which say we're doing a good enough job.
Even if that affidavit was way overbroad with regard to searching digital equipment, which I think it was, there would be an argument about severance because there's no motion to suppress any digital evidence here, right? So I would assume the prosecutor could argue, well, look at the part of the affidavit that was more narrowly tailored here, and you found the guns. You're not, like you said, bringing a jury tampering case that might have relied on some of that digital evidence.
Most definitely.
Okay.
I don't know that the phones were ever even downloaded and examined for whatever that's worth.
I mean, my guess is
Because-
once the police officers found the weapons, they're like, okay, we're good.
Our focus completely changed.
All right.
Can you help me? I have a question about the record. Did Detective Byrd, so Detective Byrd visited the driveway leading up to the trailer, right?
The roadway.
Okay. Did he ever testify as to the reason that the warrant lacked more detail?
Detective Wheat did.
But not Byrd. Like you said in the preliminary exam, was that part of the preliminary? I don't recall. If you don't, I can go back and take a look at it. I was just wondering if that was something you knew off the top of your head.
I don't know off the top of my head whether that came up at the preliminary exam or not.
Okay.
But Detective Wheat did testify about the operational reasons for not getting more specificity. And what he focused on was, we can't alert people to this. And if we have to go down this lengthy driveway, that alerts people. So that came up only in the context of, should they have done more, or why didn't they do more?
The video cam, is whose camera are we watching when we have the video? That's Bird's though, right?
At least 3 officers. You have
Okay.
Bird, Wheat, and Stewart.
Okay.
And I did sort of separate them and describe them on the pertinent points that I believed, which would be the length of the search of the separate trailer, the distance down the driveway to get to any of them, and then the proximity of the 2 that were searched. I think those are all pertinent points. They're very close. They're 20 steps apart, but they're more than a 2-minute walk down the driveway to get to even to the first one.
Thank you.
Any other questions?
No, we were tough. You did a great job.
Thank you very much.
That was excellent.
For asking the questions. I'll be anticipating a decision, and I truly appreciate the opportunity.
Well, you'll have a long drive back and you can think of all the things that you're like, oh, I should have said that. But no, the briefing was well done. It's an interesting case, as you can tell, and interesting facts, interesting law, and we really appreciate you coming down.
Thank you very much. all.
Absolutely.
Thank you. That case is submitted. Calling the 18th matter on our docket this month, docket number 373950, People v. Rimmer. I believe, oh no, Mr. Ferry waived oral argument, I see. Okay, that case is submitted. Calling the 19th matter for this month, docket number 372675, People v. White. I believe we are both remote.
Looks like it.
Okay. All right, we see Miss Morgan.
Good morning.
Good morning.
Morning.
Now we're waiting
Can I
for,
Oh, sorry.
one moment. I think we're waiting for Miss McLaren.
I think I've joined.
We hear you.
Why am I not showing? I'm not sure why I'm only being heard with audio. Let me try something here.
There you go. You're coming up.
Did I get it? Okay, good.
We think. We're closer.
I started it.
Do you have a cover over your camera?
I do not. It shows that I'm operating. Let me try one more thing. I can't figure out why I don't have visual. I've
All
never
right.
had this happen before.
Okay. Well, let's proceed. Miss Morgan, you put your name on the record and you may proceed.
Yes. May it please the court, I'm Joan Morgan. I'm here on behalf of Tamara White. There you go.
Okay.
I'm set now. Not sure what happened there.
No worries. Please proceed, Miss Morgan.
Yes, thank you. I want to talk about the first issue, which is the Franks issue that I've raised in my brief. As you know, this was a case where Judge Pickle initially granted the motion to suppress, finding a Frank's violation, and then reversed himself when the prosecution sought reconsideration. My position is that what Judge Pickle relied on in terms of his order for reconsideration does not rise to the level of probable cause to support the issuance of the search warrant. The officer in charge of the investigation, Detective Mihailoff, testified, and I think this is important in terms of the overall testimony that he gave, that he was not certain whether or not he even read the search warrant affidavit prior to requesting that Judge Crawford sign it. And if he did read it, he didn't read all of it. He admitted at the hearing on March 15th of 2022 that there were falsehoods in the affidavit, specifically when the affidavit said that when he went to my client's apartment, that E8 or EW, I'm sorry, my client's child was nude when he went inside the bathroom and saw him, and he admitted at the evidentiary hearing that that was incorrect. The affidavit itself it's absolutely comprised of statements that Officer Mihailoff got from someone at CPS, and he wasn't quite sure who he got it from. He could only recall he thought the name of one CPS worker. And on most of the averments in the affidavit, they did not begin with CPS, but more importantly, they began with some anonymous neighbor of my client who then apparently passed something along to CPS and who in turn passed statements along to the police. So it is my position that Judge Pickle's initial order was correct and his order granting reconsideration wasn't. I'd be glad to answer any questions, but that is my position.
All right, any questions right now? Why don't we hear from Ms. McLaren, and then you'll have time for rebuttal, Ms. Morgan.
Thank you very much. I've outlined on page 21 of my brief.
Ms. McLaren, can you put your name on the record, please?
Yes, thank you. Janet McLaren on behalf of the people.
Thank you.
I've outlined on page 21 of my briefs the search warrant, the facts that were laid out in the affidavit. If you excise the unintentional false statement, which we agree, there was testimony about EW being found nude. But if you look at I believe I have a page and a half of them, that when you excise those under the Franks v. Delaware case, there is still adequate probable cause, which is the question here, is whether or not there was adequate probable cause.
Does it matter that some of the information was obtained apparently from a CPS person whom the officer could not remember?
I think the important thing, as I've laid out in my brief as well, that, when you look at CPS or DHHS, they're not really an informant or an anonymous person in that sense of the word. They are an agency. I cite the case in there about the individual that was at the mall and was in the course of his employment and taking reports. It's the same sort of situation. And DHHS or CPS, I guess, as they were referred to at the hearing, they have policies and things that they must follow in order to document these things and to turn them over to the police. And also the adoptive mother was named in what they gave the police. That was not an anonymous source. That it did come from CPS, but it was not an anonymous source. So they're just not an anonymous source in the traditional sense. When you look at their information combined with all of the four corners of the document as is required under the Gates test, there's just sufficient probable cause here.
Okay. Any questions
No.
Ms. Morgan, you have time for brief rebuttal.
The only thing I'd like to say is that I don't agree with the analysis in terms of the anonymity of the statements because I think it's common knowledge that anonymous communications can be made to CPS. They were in this case. There's no basis for credibility or reliability in terms of those. And the fact that those statements were repeated by CPS does not give them credibility or reliability.
Okay. Any other questions?
No,
All
thank
right,
you.
thank you. We appreciate you appearing for oral argument remotely, and the case is submitted.
Thank you.
Thank you.
Calling the 20th matter for this month, docket number 372530, People v. Sinclair. I believe we have Mr. Middlestat who's appearing remotely. Okay. Good morning, Mr. Middlestat.
Good morning, Your Honor. Mike Middlestat of the State Appellate Defender's Office, appearing on behalf of Mr. Sinclair, who, as you know, is appealing his conviction for fourth-degree CSC. I kind of feel like after listening to this case call that I'm a bit of an outsider because I'm not. It seems like it's Fourth Amendment day there at the court, and I certainly don't have a Fourth Amendment argument to present. But anyways, I think I've covered pretty much almost everything I wanted to, the points I wanted to make in the brief, and I'm prepared to rest on the pleadings at this time and answer any questions the panel may have. But I would like to make two very brief points.
Please do.
So the first is in response to my opponent's assertion that the prosecutor, in fact, did not argue facts not in evidence because the complainant, in fact, had testified that he told Officer Moore the same thing that he was telling the jury. That's not accurate. If you look at page 96 of the trial transcript, the complainant the complainant actually testified that he gave a statement. He didn't say what he said, but he gave a statement to Officer Moore. Now, there's a big difference between the fact of a statement and the content of a statement. So I would contend that our argument is valid, that there was facts not in evidence referenced by the prosecutor in an effort to bolster this complainant in a credibility case. The second point I'd like to make is just to sort of emphasize the context of this trial here. This occurred in a very small town. I think it's about 2,500 people, likely very tight-knit community, and likely a community of people who probably, there was a good chance they knew everyone who lived there. Mr. Sinclair, in contrast, was the outsider. As we know from his police statement, he was in town as a temporary worker from Las Vegas. And so I think in categorizing Mr. Sinclair's actions or Mr. Sinclair himself as weird, as odd, and then putting himself in the shoes of a community member by saying, hey, I would never do something weird like this. I think the prosecutor leaned into that dynamic. He leaned into the dynamic that this person who already is somebody who should be viewed with skepticism or with distrust is even weirder and more dangerous, and we can't allow him in our community.
Mr. Middlestat, is there any indication? Is there any indication that the jury was exclusively from this small town?
No,
Okay.
no, there is not, Judge. I won't claim there was, but
Okay.
I think we can assume that Oceana County is a very low population. So.
Okay.
Yeah, my notes say that the prosecution used the phrases "that's weird" and "it's weird." Did I miss one where he said he's weird or?
No, I will concede that as the prosecutor argues, he did not call Mr. Sinclair weird, but I think the implication was pretty clear that he's doing stuff that we don't do in this town, and he's the outsider there. So,
okay.
on top of that is sort of the elephant in the room. And, this allegation was made of sexual assault of a minor and same-sex sexual assault by a minor. That at this time, that was a really hot button issue in our nation's cultural wars. So I think, seizing on that and seizing on sort of the moral panic that unfortunately was going on at this time, the prosecutor, in emphasizing the otherness of Mr. Sinclair, that added more punch to his improper comments. And then again, unless the panel has any questions, I'm prepared to rest on my brief there.
Okay, why don't we hear from the prosecutor and you'll have some time for rebuttal, Mr. Middlestat.
Thank you.
Good morning, Your Honors. Monica Wilson, Assistant Attorney General on behalf of the people. Just a couple of quick points to touch on. Judge Maldonado, as you mentioned, the reference was to the conduct, not to the defendant as being weird. And I believe that was proper because one of the things that the prosecution had to demonstrate was, as an element of the CSC, that the contact was for a sexual purpose. And I think the reason for those comments and that argument was to show that there was no innocent explanation for the behavior. So I think that was, and prosecutors don't have to use the most bland language, I think is the case law. So I think, and I don't think he was trying to so-called other the defendant. I don't think there was any reference to where he was from. In any insinuation that this was somehow based on this being a same-sex relationship, obviously the jury can see that the defendant is male. They can see that the complainant is male, but there wasn't any reference to, there was no highlighting, so to speak, of the fact that both of these individuals were men. So I don't think that came into it. So unless your honors had any questions, I would just rely upon the brief.
No, thank you.
Thank you, judges.
Mr. Middlestat, you have some time for a brief rebuttal.
Yes, Judge. I don't think I have anything to add unless you have any follow-up questions there.
Nope, I think we're good.
Okay, thank you, Judge.
We appreciate your involvement in oral argument today, so thank you. That case is submitted. Calling the 21st matter on our docket today, docket number 373248, People v. Slike. And I believe we have Mr. Branch appearing remotely and Ms. Wilson appearing in person.
Okay, yes, Judge, William F. Branch, attorney for the defendant. Okay, I think I've actually got everything turned on here. So the operative word I hear as you're talking this morning is talking about these cases being interesting, and I'm sure they're intellectually challenging. And it's not usually my intention to come up before you and depress you. I usually try to do just the opposite. But the operative word here in this story is sad. This is another sad story from the far reaches of the Upper Peninsula. And it involves, as you know, Dean Slike and his teenage daughter.
Please do not say the name of
No,
the.
I think the defendant's name and the daughter.
Yeah, there's no sexual aspect to this.
Well, but we still don't refer to the daughter by name. I didn't think you did, but I could be wrong.
Okay.
So if you did, don't do it again.
Okay. Dean and his daughter, S, we'll call her S. And S's mother, or Dean's wife, had died sometime previously. We really don't know when. Now, the state in their, as I read their brief, they said, well, I tried to narrow this down to too much factually. So I'll expand it on it here just for a moment and say that what's obvious here is reading this is a family that never recovered from the death of the mother. Dean?
Well, Mr. Branch, I mean, I understand that, horrible things happen in terms of deaths in the family, but you raised a sufficiency of the evidence argument, not some kind of duress or diminished capacity argument. So why was there, on what element was there not sufficient evidence here?
Okay, so that brings us back to the narrow question that I tried to address as far as the elements of second-degree child abuse. In particular, one of the elements is cruel, which is defined as brutal, inhuman, sadistic, or that which torments, regardless of whether harm results. So that's what we have to narrow in on. And what do we know? Well, we know what Mr. Slike did because there's some agreement here. He was charged with strangulation, but the jury rejected that, and rightfully so, I think. S initially told the police that he put his hands around her neck but didn't strangle her, and she changed her story after speaking to family members who were trying to get her away from her father. Mr. Slike used the phrase, he choked her like a chicken, but based on curious family history and evidence, we really don't know what he meant by that. But we do know, because it's agreed, that at some point he hit her, either on her arm or on her side. Neither the police nor medical professionals observed any physical injury. She did not claim injury. When offered further medical treatment, her response was, "No, I'm good."
What about the testimony or the possibility that the jury acquitted on strangulation because there was no physical injury, but abuse, second-degree child abuse, doesn't require physical harm? So couldn't the jury have said, yes, we believe that the father strangled the daughter, not to the extent that he'd be guilty of strangulation, but to the extent that he would be guilty of second-degree child abuse? Why is that not just a rational view of the evidence?
Well, Judge, because we have to, again, look at the evidence and what was the evidence as far as we're talking about the strangulation. As far as we're talking about the strangulation, all we're talking about here is that at some point he put his hands around her neck but did not squeeze. That was her initial statement to the police.
In the light most favorable to the prosecution, there's evidence that defendant struck the victim, choked her, destroyed household property in anger, and threatened to turn the house into a crime scene.
Yes. So there is no evidence that, in fact, he strangled her, because that's not what she told the police.
What did she testify to?
She testified that, she initially testified that he strangled her. Then when questioned, she admitted that, in fact, she did not tell the police that he ever that he ever squeezed her throat, that she had changed her story to that after speaking to her family and to the prosecutor.
Well, I think correct me if I'm wrong, but I thought it was just that she could still breathe, that it hadn't blocked her airway, not that he hadn't squeezed, but just that she could still breathe.
Now, her initial statement to the police was that she did not experience any trouble with breathing. She said he put her hand around my throat, but did not experience any trouble with breathing.
I'm less focused on what she told the police and instead more focused on what she told the jury. And you rightly point out her testimony. I think you could say there was inconsistencies, but those inconsistencies are for the jury to sift through. It's not for us, correct?
Well, that is true, Judge. But what I like to point out in these matters is some of the words of that are more favorable to the defense from this court and from the Supreme Court as years go by, particularly in People versus Williams, which this is really elementary. The evidence is insufficient if it could not support a finding of guilt beyond a reasonable doubt. But more important than that, even, is this wording from People versus Hampton, which says that in quantitative terms, the fact that a piece of evidence has some tendency to make the existence of a fact more probable or less probable does not necessarily mean that the evidence would justify a reasonable jury in reasonably concluding the existence of that fact beyond a reasonable doubt. Now, if we look at what's required here of the statute, the definition of cruelty, this brutal, inhuman, or sadistic, or that which torments, it's not reasonable to find that this actions from Mr. Slike qualified under any of those. we have to bear in mind also that a parent is allowed to use reasonable force in disciplining a child. This is a child who was refusing to do her homework, was refusing to help with household chores. And the evidence, even from the counselor who testified, was she was doing this intentionally to get her father mad so she could get out of the house.
Right, and these were arguments made to the jury. But I think you would, correct me if I'm wrong, you would agree that if there was evidence that he punched or choked or smashed dishes in a very violent way, that would not be what we would consider appropriate corporal punishment. Fair enough?
I would part with you on the smashing dishes. I don't see how a parent getting so frustrated with a child that he smashes dishes falls under the definition of child support. Just as
But punching or choking a child certainly does not fall under any definition of appropriate corporal punishment. Fair?
Yes, fair, but also it depends on the level of force used, and we don't know here what the level of force was. We know that it did not leave any type of bruise or injury, and that she declined medical treatment. So we don't know what level of force was used here.
Okay. Any other questions?
No.
All right. Why don't we hear from the prosecutor, and you'll have time for rebuttal, Mr. Branch.
Thank you.
Good morning again, Your Honors. Monica Wilson, Assistant Attorney General on behalf of the people. Your Honors, this is brought under sufficiency, so it's in the light most favorable to the prosecution and to the jury's verdict. We have a man who was upset that his middle school age daughter wasn't doing her homework, which I think is pretty typical middle school behavior. In response to that, he hits her, he kicks her. Whether he choked her or put his hand around her neck, however it's worded, he placed his hands around her neck, which was something he admitted, even though he and some witnesses claimed it was a joke. I think the jury was free to disbelieve that testimony and decide for themselves what placing your hands around a 13-year-old's child's neck means. And then you have, he's stomping, he's breaking dishes, and then you throw in the fact that this child's mother had recently passed. And he's threatening suicide. He's threatening to kill himself because she's not doing her homework. And then he's threatening to kill any police officers that come to the home.
Didn't he threaten suicide by cop?
Yes.
Okay.
With that, I mean, let's assume for purposes of this conversation that he did threaten suicide by cop. Would that fall under second degree child abuse?
In and of itself, maybe not, but when it's in the context of the entire conversation and the recent passing of her mother.
It's really the physical laying on hands of her that I think is what you're primarily relying on.
That's the primary focus, but I think if you also, even if you look at the entirety of the circumstance plus this child's things that had recently happened in her life, I think give them some greater context.
What about, I think defense counsel in his brief and in his oral argument indicated that her story did change. And there were, I think it's fair to say, inconsistencies in her testimony were brought out. And then there was also some evidence that this might be a setup so that she could go live with her aunt. What do we do with that evidence?
Well, in the sufficiency context, I think you have to look at it. It's a quintessential jury question of credibility that, the jury heard a lot of testimony about the relationship with the aunt in Wisconsin and that this child wanted to go live with the aunt. And part of, I think, Dad's defense was she's making this up because she's trying to get out of my house. She wants to go back with her aunt. I think for a time she was with her aunt after mom passed. And then I believe a different court ordered her home. I think that was part of the record. And so, but if it's a credibility question, I don't think you can resolve in the defendant's favor a sufficiency question based on credibility. The jury heard all of that. And I think the reasonable inference from the verdict is that they credited this child's testimony as opposed to the father's and his family members. So it's a quintessential credibility contest, which I don't think a sufficiency argument is the place to resolve that.
No, thank you.
All right,
Thank you, judges.
Mr. Branch, you have time for a brief rebuttal.
I don't think he ever took the position that it was a joke, this thing of putting her hand around her neck. As I recall, what he said to the police was that I choked her like a chicken. Now that sounds terrible until you look into the family evidence and see just what that phrase was. I mean, it was a statement that the police didn't explore. And so we don't know anything more of that. I don't think he ever meant it as a joke. I'm bothered by this threatening suicide, though, being used as an aspect of child abuse, especially in this type of a situation. This fellow was subject to depressing circumstances, more so maybe than even the child was. He had lost his wife. He was being subjected to her a constant disobedience, quite possibly intentional to try and get away from him. I didn't read that statements of suicide as even directed at her. It sounded to me like he was talking to himself as he was walking about the apartment. So I'm bothered by that. I'm bothered by that.
Mr. Branch, I think, as the prosecutor said, that certainly is not something that alone
Yes.
would fall under child abuse. Is it a relevant piece of evidence? Possibly in some situation, but I think here there's much more material evidence with regard to child abuse that we just have to look at and see whether it was sufficient here.
Okay, thank you. I'll be all done.
Judge Maldonado, did you have something?
No, it's fine.
Okay.
You said it. Thank you.
Okay, thank you. All right, the case is submitted.
Thank you.
Thank you. Moving to the 22nd matter on our docket number 374665, Jones v. Hammonds.
Good morning, Your Honors. Richard Brewer on behalf of Ms. Jones. The
All
plaintiff
right,
appellant in
one
this matter.
second. We have, I believe, Mr. Shiner.
Shiner, Your Honor.
Shiner. Okay. All right, Mr. Brewer,
Yes, Your Honor.
please proceed.
Thank you, Your Honor. Just to put this matter in perspective, the trial court in this case was called upon to decide 4 issues on C10 motions for summary disposition relative to the nature and extent of my client's injuries, in other words, whether she suffered a serious impairment of a body function, whether there was evidence that the defendant was at fault for the accident, whether there was evidence that the defendant truck driver was not properly trained. Excuse me.
I think on appeal, aren't we focusing on impairment?
Absolutely, but I want to put my client's injuries into context. My client testified, and I'm do this because the trial court has the obligation to determine whether there is any evidence that would allow a reasonable jury to decide in favor of my client on the particular issue that's contested. He's not there to decide the credibility or the weight of that evidence. He's there to determine simply if there is evidence.
We understand the C10 standards.
So
what is the evidence of impairment here?
Certainly. Your Honor, my client was treated at Northland Radiology by Dr. Kripchek. Dr. Kripchek had MRIs performed which showed objective manifestations of injury, particularly disc bulges in the neck and in the lumbar spine. He found EMG evidence of radiculopathy going from the lumbar and the cervical spine into her limbs. He issued disability certificates, which were part of the record, wherein he opined that these problems that were disabling her were the result of the motor vehicle accident that she suffered.
So you indicate that there's evidence of injury. What's the next step in terms of how does that show impairment? What was impaired about her?
My client testified under oath that she was impaired to the extent that she could not conduct her normal activities. She required assistance doing household services. She couldn't walk or stand for protracted periods of time. She could not engage in her normal recreational activities. In other words, these injuries, her inability to lift, to be mobile, to stand for periods of time, to sit for for protracted periods of time and to walk for normal distances were all impaired. And that's in her sworn testimony. The judge had that before him. In determining these motions, he correctly decided 3 of the 4 issues, which I take no umbrage, but I do contest the fact that there was no evidence that she suffered a serious impairment of a body function. We've got objective manifestation. We've got impact on her ability to lead her normal life. And it's all attested to by a licensed physician and my client's sworn testimony. The court
You
should.
said it's attested to by a sworn physician. Did this physician provide an affidavit?
No, disability certificates, Your Honor, which he signed, which said that I am treating this lady for injuries sustained in this motor vehicle accident. These injuries have caused these particular
These
diagnoses.
certificates that he signed, are these signed under penalty of perjury, or are they sworn in any way, or are they just like a doctor's certificate?
They are part of the medical record, doctor's certificate, part of the medical record, which was submitted to the court. And therefore, it's our position that the court should have determined that there was a genuine issue of material fact and let the matter go to a jury.
Okay. Any questions? All right, you'll have time for rebuttal.
Thank you.
Mr. Shiner?
Yes, good morning, Your Honors. David Shiner on behalf of Appellees Cross Appellants David Hammonds and Grain Transportation Line. Summary disposition was properly granted based on the conclusion of the trial court that the plaintiff did not make a sufficient showing of a threshold injury required under MCL 500-3135. Plaintiff, in support of her position before the trial court and on this appeal, presents several imaging studies, what amount to be essentially imaging studies of every part of her body. Those imaging studies range from showings of no findings whatsoever to some degenerative changes or findings of normal degenerative changes, like the MRIs of the cervical spine and the lumbar spine. What's absent from the record is any evidence, any testimony or opinion from any doctor that these findings on the spinal MRIs were caused or exacerbated by this motor vehicle accident. So in order to establish a serious impairment of an important body function, the first element requires an objective impairment, and that must be established by some testimony or documentation of a physical basis of that impairment. And
so what about, you heard opposing counsel point to the treating physician certificates? Why was that why were those not objective? Why was that not objective evidence of impairment?
Well, so like Your Honor asked, that is not sworn testimony. Those are not signed under penalty of perjury. And what they say is they reference a date of an accident and they say, you know, it fills out a disability. But what's missing there is connecting it to this motor vehicle accident and connecting.
But Mr. Shiner, that's causation. That's making a link between an impairment and the cause of that impairment. And I understand you have arguments on that too, but I'm focused more on the impairment. Has she shown, is there any evidence in the record of the objective manifestation of an impairment, in your opinion?
Well, no, because the only real complaint is just generalized pain. But what's missing is the objective source of that pain, how it objectively impairs her. I mean, again, there's no objective finding of an injury, and I understand that there is a differentiation between an objective injury and an objective impairment. And when she's just saying, I just have generalized pain, when no one can really, no one's testified to the source of that pain or the physical basis of that pain, what we're left with is just pain. And also, so going back to the disability slips, I mean, it has, they have each at the top, date of accident, 8/15, and then it just says she's disabled. But we've also presented medical records that in the past she has been treated for and has had injuries that resulted in a lot of the impairments that she's currently, or she was currently complaining about. So what's also missing is some evidence or some testimony establishing that it was because of this that these complaints of pain are because of this motor vehicle accident, as opposed to any other cause or any pre-existing conditions. And that's really what is missing here from the causation element of things. Moving to the impact, the second element of the objective impairment is the impact on her life. Plaintiff has presented some testimony that she says she's limited, but not necessarily. She didn't go as so far to say that, and this has impacted my ability to lead my normal life. She has started several businesses. She's been very active working full time. Those include a doula business, a hairstyling business, a house rehabilitation business. She's worked as a minister, and she's traveled extensively. So when we're talking, and again, as far as the source or the basis for the limitation, if it's just generalized pain, there's not anything explaining exactly, what the cause of that was and differentiating it between any previous pain for which she received treatment in the past. So when we're talking about essential tasks of daily living that impacted her ability to lead her normal life, that is what's missing here.
Okay. Any questions? Okay. Thank you, Mr. Shiner. Mr.
Thank
Brewer,
you.
Thank you, Your Honor.
we have time for a brief rebuttal.
Certainly. The disability slips of Dr. Kripchek are not ambiguous. They say that he's treating her for the injury sustained in the motor vehicle accident. These are the injuries. He lists diagnoses, and then he lists her disabilities or impairments. Although not done under oath, they don't have to be, as long as they would be admissible at trial, which these would be as a medical part of the medical record. Ms. Jones specifically testified as to the impairments that she sustained and the effect that those impairments had upon the way she lives her normal life, including, the counsel mentioned hairdressing. Well, she had to stop doing hairdressing because she couldn't hold her arms up. She testified to that. That deposition is attached as an exhibit to my brief. And in my brief, I identified the pages where that testimony is found. So question is, did the trial judge have evidence, whether he believed it or not, that would allow a reasonable jury to conclude that she suffered a serious impairment? And I contend that he had that evidence before him and he shouldn't have granted the motion.
Okay. Thank you. We appreciate it.
Thank you.
That matter is submitted. That completes the 10 o'clock portion of our case call today. And we're going to take a brief recess and we'll be back in 10 minutes or so. All right, moving on to the 23rd matter on our docket this month. Docket number 367352, Mayberry v. Acrisure Wall Street Partners, LLC. Please proceed.
Good morning, Your Honors. Gaten Gervillarash on behalf of the Acrisure entities. I intend to reserve 7 minutes for rebuttal, if I may. May it please the court. The overarching issue here is whether a limitation period for claims arising out of Mr. Mayberry's employment that he agreed to in signing his application for that same employment bars as untimely his claim for breach of an alleged 2019 amendment to this employment agreement. Now, the trial court held that the limitation period in the application was superseded by the employment agreement because of an integration clause, even though both the application and the employment agreement were handed to Mr. Mayberry on the same day. He signed them on the same day, and they came with a letter that said his employment was contingent on completing both of them. What the trial court's holding is contrary to law for two
The
reasons.
employment agreement says it supersedes any and all prior agreements and that it represents the entire agreement, that it can only be modified by express reference to it. Doesn't matter if they signed two documents at the same time, that we've got to read that language. I mean, that's how we.
We
read
do,
contracts.
but under Michigan law, we have to read the agreements together because one is dependent on the other. First of
Doesn't
all,
cross-reference it. It
it doesn't matter, Your Honor. They were signed on the same day. And there's a letter that he signed, in fact, afterward, which by the way, you don't, it does, that one cannot be superseded. The letter cannot be superseded by an integration clause injured before that says your employment requires you agreeing with both of these.
Do you have any cases where there's an express integration clause with language this strong where we've read them together despite no cross-reference to the second contract?
Despite no cross-reference, no.
Well,
But we
I think
have-
this would be unique then.
But we have doctrine. We have doctrine that says when the contracts are signed at the same time, contemporaneously, and they
Again,
relate to the,
but that would, I think that would only, I think that could in theory apply it in this situation if there was no express integration clause, but there is one.
well, it's kind of nonsensical to apply an integration clause to the employment application when it's for exactly that employment and it was handed to them on the same day. The only cases where it has been determined that you don't, there's a question about whether the parties intended that those terms in the application apply, where the employment happened a year later or so.
So would you admit that if these documents were not signed on the same day, at roughly the same time, I don't really care whether it was an hour or two different or if they were signed at the same time. If they were signed, a month different, that we would have to read the integration clause, meaning that we only look to the employment agreement?
For the conditions of employment, yes.
Okay.
But that's why we argued in our brief that alternatively, if you're not going to read these as one agreement and you're not going to apply the doctrine that says when one contract's dependent on.
I'm only asking about whether we should read them together or not.
Right. And
So if there was a greater amount of time in between the signing of these two documents, would you concede that you really look at the document with the integration clause and you can't read them together?
yeah, I think we'd have a much harder argument.
Okay, because you
in
see that all the
situation.
time with, term sheets that are signed, and then 2 months later, you have a final agreement, and that term sheet no longer controls because of the final agreement with an integration clause.
Correct.
What about the fact that the two documents were actually signed by two different entities? You have the employment application, which was made on behalf of Acura, and then the employment agreement was actually with plaintiff and AWP.
Well, our response to that is threefold. First of all, the trial court did not accept that argument, by the way. And I don't think a reasonable juror would either, because the
I'm
letter.
going to stop you right there. We are asked all the time, and it's usually by corporate defendants, to read corporate structure, to understand that separate corporations and separate LLCs should be treated separately, right?
Correct.
And this seems like, it almost seems like on the one hand, usually you might be in the position of arguing that those separate corporate entity structures should be respected. But here you seem to be arguing that no, they shouldn't be respected. They're the same entity.
But here we have more.
Okay.
We have concessions by the plaintiff that he understood that this was an employment application for the employment he acquired. Okay. That it was an employment application for AWP employment. And secondly, we have a letter notifying him of that that's what this employment application was. So that's why I say there's no reasonable juror who would say that he didn't understand that employment application applied to the AWP employment. And on top of that, you've got some ambiguous.
So even though it says Acura, you believe that there's evidence and it's clear that he understood this was really AWP.
Yes, both in terms of the context, and in terms of the context, his the letter that he was provided that explicitly said so, and his concession at the deposition that he understood that. All three of those. In terms, back to the point about if you just read these in the abstract, you don't consider any of the circumstances, the fact that they were contemporaneous, and you don't apply the doctrines that require them to be harmonized, then you can't consider the employment application to be conditions of employment. Because even if he had not been employed, he would still be bound by the employment application. In that event, it's just a separate agreement. And it's only if it varies or contradicts.
But didn't the second agreement, didn't the other agreement say it nullifies all antecedent agreements?
No, it did not. It said prior employment agreements. And the application itself alone is not an employment agreement. Now, if you read these as one agreement, you can consider them then to all one employment agreement. And I think that there's a good argument that it could be read as one agreement. I think that
It says it supersedes any and all prior agreements between the employee and the company. It doesn't say employment, but like that part of it doesn't say prior employment agreements. It says it supersedes any and all prior agreements between employee and the company at one point.
Where are you reading that, Your Honor?
Where my notes at. "15 acknowledgement. This agreement supersedes any and all prior agreements between employee and the company." Section 15 of the employment agreement. Paragraph 15.
I'm looking at the 2018 employment agreement. Is that what?
Yeah, paragraph 15 acknowledgement.
Yes.
This agreement supersedes any and all prior agreements between employee and the company, including any agreement between employee and company's predecessor company, whether verbal or written, express or implied.
Okay. Well, the actual text says this agreement supersedes any and all prior employment agreements.
Are we missing employment? Am I missing employment in paragraph 15? Let me pull.
Yes, unless I understand you're looking at your notes. If you look at page 11 of our brief, we have a block quote there that sets out both of the, what I would call them both integration clause of sorts.
Can you do a citation to the record, like your appendix maybe?
Yeah, it's appendix 191.
I'm sorry, I didn't hear you.
191.
Thank you.
Well, and we can get, because I have the same, it's supposed to be a quote of paragraph 15, the same one that Judge Ackerman is looking at, and we'll just make sure that it's been accurately transcribed.
Yeah,
The plaintiff's counsel is indicating that you are correct. So we'll just go based on that you're correct.
Right. And so that's why one of our arguments was it's just not in conflict.
So the claims that plaintiff is making, do those arise out of something that you could say was part of the application in terms of maybe a discrimination claim? He was hired, but typically you would say, well, a claim out of an application might be some kind of a racial discrimination claim or something along those lines.
Right, for not being employed.
Right.
Right.
But since he was employed, is he really making a claim based on his employment application agreement or his employment agreement?
Well, I don't think the question is where does the claim arise out of, because the employment application specifically refers to claims arising out of your employment. All right. But it's a condition of consideration of the application rather than a condition of employment.
Okay.
That's how we look at it. There are two other defenses that were raised. I mentioned the first one we discussed that was not accepted by the trial court. The second one also was not, and that's that he could not have known that there was a breach before he was fired, and therefore regardless of whether the limitation period applies, the claim is not barred. First, I point out that he pled out of that. His complaint says that effective March 1, 2020 is when the alleged agreement took effect. Secondly, that he failed, he was not paid following the March 1, 2020 effect of the agreement. So he knew at the end of March that he wasn't paid, and it was made explicit to him in May. The only uncertainty here and he tries to rely on this uncertainty about whether, they're going to cure this, but that's not uncertainty about whether a breach occurred. That's uncertainty about whether it will be resolved and whether the breach will be cured. And he certainly knew that.
Going back to 15. So this agreement supersedes any and all prior employment agreements. Is that the proper?
Correct.
And you want to draw a distinction, and this question is based on an assumption that we're not going to agree with you in terms of reading them as combined, but we have to look at them separately. So I think, correct me if I'm wrong, but one of your arguments is that, well, if we have to look at the employment application says that any and all disputes involving your employment are subject to the shortened period. Is that correct?
Correct, something like that, yeah.
So wouldn't that given that fact that the employment application deals with stuff that's broader than the application, it deals with something, for example, if you bring a claim, anything based on your employment is subject to this, shortened time frame. Wouldn't that then mean that that's a prior employment agreement? Because it deals with, if you want us to read the employment application agreement to be broader than just the application, because it has this condition that applies to all aspects of the employment, wouldn't that make the employment application agreement a more generalized employment agreement?
I would disagree.
Okay, so we read it one way, it's an employment application, but you want us to apply it to more generalized employment conditions.
I want you to apply it to the claims it says it applies to. It's a term of an application, and that term says, here's what you're waiving, and that waiver applies.
And you're waiving things that are beyond the application that could actually go to the conditions of your employment, if you get it.
Or it could go to other things. I don't think
Okay.
it matters what it goes to. It matters where is the condition, what agreement is the condition in?
And that
Is it an
doesn't make it
employment
that doesn't
agreement?
make it a prior employment agreement?
Oh, it makes it, no, it's not an employment agreement. He's not employed just because they agreed on the application that they were going to consider.
Even though he's giving up certain rights if he is employed. He's giving up a longer statutory limitation.
Well, he's given up the right before he's ever employed. He's not been employed yet. He's already giving it up. Now, it doesn't matter, of course, if he's never employed, because he's not going to have any claims that arise out of an employment. If there are no further questions, I'll reserve the remainder of my time.
Sure.
Bob.
Okay.
Thank you.
Let's hear from plaintiff's counsel.
Good afternoon,
There you go.
Your Honor. Presiding Judge Swartzel, Judge Ackerman, Judge Maldonado, how are you all today?
Doing well.
Thank you.
Good to see all of you. Yeah, I mean.
Can you make your appearance, please?
John Muthart, Your Honor, on behalf of plaintiff appellee Ty Mayberry. In order for this appeal to be successful, just want to set my understanding of what's before us. The appellant must demonstrate first that the 6-month limitations period is part of Mr. Mayberry's employment agreement. The agreement that the trial court found in a prior order that's not on appeal here was fully integrated. If you'll recall, there was a 2-step process. There was a summary disposition hearing pursuant to which the trial court said, we need to I'm going to deny all this other stuff, but we need to take a closer look at the 6-month issue. But in the first order, the trial court ruled that it's a fully integrated agreement, and that's mentioned in the second opinion.
Right, but everything's before us de novo. So why should we read this integration clause as, basically bumping out the employment application?
You're messing up my introduction, Judge.
I mess up a lot of things.
I will get to that in a moment, but there are three things really that the appellant must establish. First, that it's a part of the agreement. Second, that the 6 months is reasonable. And third, that Mr. Mayberry missed the 6 months. And so in response to your question, the first thing that I would say is that, you know, this employment application is not part of the employment contract for some of the reasons that y'all have been discussing. Mr. Mayberry was never employed by Acrisure LLC. Never was. And that is the only company name that is on the application. There's
What
no
about opposing counsel's argument that plaintiff pretty much has conceded that he understood that that agreement was with AWP?
I'm not aware of any testimony, deposition testimony or otherwise that's been cited in that regard. I mean, if there is some, that's a legal opinion by my client, I suppose, but you know, I mean.
Well, no, it'd be a
a
factual understanding. If he knew that he was applying for AWP, does it really matter what name is on the application? I mean, that's the question I'm asking.
I think it matters a lot because this is a situation in which obviously we've got an employer entity that is sort of presenting sort of a quantum theory kind of, you know, hypothetical here. It's like Schrodinger's cat. The cat's dead and alive in the box at the same time. These companies are the same, but they're separate too. And we want you, Court of Appeals, to collapse these two entities and say that this agreement that is with the parent company, Acrisure LLC, applies to the subsequent employment agreement with the subsidiary, which is Acrisure Wall Street Partners LLC. And they are not the same entity. I'm sure that Acrisure LLC, which has numerous subsidiaries, would not want to be considered to be the one and the same as all their subsidiaries. I mean, the point you made, Judge Schwartzel.
If that's the case, how could you make a claim for breach of contract against Acrisure itself? Wouldn't you only have a claim against the party that you've contracted with, AWP?
Yeah, I mean, that's in the pleadings of you know, I can't really take responsibility. I don't know the answer to that question.
The argument
I don't
could go,
believe,
I think Judge Ackerman's point is well taken. It could go both ways. I mean, it may not be particularly helpful for defendant right now, but it also may not be particularly helpful for you if the case continues.
Yeah.
And
I think that is not before you, Judge Ackerman, I guess is what I would say. But in the event that the trial court finds, which it has not found at all, I think brother counsel did mention that the trial court rejected this argument. I don't see any evidence that the trial court considered this argument about the separateness of the entities. And so I don't think it's accurate to say the trial court rejected it, unless the fact that the trial court didn't mention it at all is implicitly rejecting it. It's not a base of the trial court's ruling. We can all agree about that.
what about the argument that opposing counsel makes that these documents, these agreements were executed at about the same time? You know, maybe at the exact same time, maybe a minute apart, maybe an hour apart, but the same day at least.
Can't imagine why. Sorry.
Why shouldn't we read them together? Like everything that he signed, you know, like almost like a closing for a piece of real estate. You read it all together. Why wouldn't you do the same here?
Well, as I mentioned, there's no mention of the employer entity in the application. There's no mention of the application in the actual employment agreement, which is something that Judge Ackerman has already questioned brother counsel about. The employment agreement is an agreement. It's signed by the employer, Acrisure Wall Street Partners LLC, and it contains the terms of the employment. The application isn't signed by AWP, anybody at AWP. There's no mention of AWP in it. However, I do think that in regard to the merger clause in the employment agreement, and the idea that this application is not an employment agreement, I think is mistaken.
How can it be?
Well, if one looks at, and this is in the record, it's in the appellant's appendix, page 196, there is a big, long set of terms under applicant statement. I know you can't see it here, but the headings are affirmation, everything in the application is accurate. I authorize the company to investigate that information. I promise I'm not using drugs or alcohol. But it also, there's a big long paragraph about at-will employment. I mean, that's an employment agreement. There's a release of, I mean, this is.
I think there's no question the employment agreement is an employment agreement. The question is.
This is from the application, Judge.
That's the application?
This is the application. I'm saying the idea that the application is somehow excluded from the world of quote unquote employment agreements is contrary to the actual terms of it. I mean, the first few pages are checking boxes, filling out names, providing a little bit of information, but the last page is full of employment agreement terms. And whether you call them conditions or terms, I've never really understood from my position as sort of an outsider to this. I'm doing the oral argument. I didn't do the trial court work. But I mean, what difference does it make whether it's a term or condition? I mean, the employment agreement is fully integrated. The trial court has ruled that in an order that I believe is not on appeal here. And so now we have to look at this other document that is with a separate entity and say, as a matter of law, it's part of the employment agreement. And I don't think that that's possible on the facts of this case. The letter, there was also some brother counsel talked about the letter that my client, that Mr. Mayberry signed. He signed it on April 18th, substantially after he signed the employment agreement, as we concede. But it seemed like there was some brother counsel said that the letter, appellant's appendix 197 and 198, is with AWP. This clarifies that this is employment with AWP. It does not say that. It says my anticipated start date with Acrisure LLC. First page, Acrisure LLC is also pleased to offer a comprehensive benefit program. It says Acrisure on the top. It says nothing about Wall Street Partners. Similarly, if you look at the appellant's argument about the 2017 employment agreement, they say, hey, this is just a rerun of that. This is what we did a year before that. He signed this stuff, Acrisure and Acrisure Wall Street Partners. It's kind of all the same thing. And this is quoting from the appellant's brief. This obliterates any fact issue. I would beg to differ because the 2017 packet, actually, unlike the 2018 packet, says at the very top, Acrisure Wall Street Partners LLC, right on the application. The 2018 application does not say that. It's different. And so to the extent that we're going to look at this really big stretch, in my opinion, right? This is an agreement that we're trying to, as the appellant, assert is some sort of parole evidence that you should consider in collapsing these entities. Okay. I mean, let's say that's okay. It cuts the other direction. This has got fact issue written all over it. The old application said AWP right on the application. The new one doesn't. The implication from that is this is different this time. This is a different application with a different entity. So it really does cut against the idea that these two agreements are with the same company. I mean, they're not. There's just no evidence that they are. Acrisure, as I think I mentioned earlier, the record is pretty clear as the parent company of AWP. The application doesn't say, for example, like maybe it could have. Acrisure LLC is the parent company of a lot of other, insurance companies. And so we have you fill out this application, because this is, I think, the story. We have you fill out this application to be employed with one of our subsidiaries or one of our family of companies, one of our Acrisure entities. It doesn't say that. It doesn't say that at all. It just says Acrisure LLC. So I don't think that it's, these, as I indicated, these entities either have to be separate or the same. They can't be both at the same time. And there's no evidence, there's no factual basis to say that they are the same. And those are the entities with whom these two agreements, if you can call them, exist. I mean, the application again isn't signed by anybody but my client. The merger clause says it's the entire agreement between the parties regarding the terms and conditions of employees' employment. Plus, it says all prior employment agreements are superseded, which includes this document that's got this big page of stuff about how your employment's at will, the statute of limitations is reduced to 6 months. How you can say that's not an employment agreement, I'm not sure. It also says this agreement, quote unquote, with a capital A, governs the employment relationship. There's no mention of the application in the employment agreement. There's no ambiguity in the employment agreement. There's none been even alleged, to the extent that the trial court has, as I indicated, held that it's an integrated document. And so there's no parole evidence allowed. I mean, and you would have to find, in order to believe and to rule against, to reverse the trial court, that as a matter of law, that application is not an employment agreement. And so it's not included in the merger clause. I mean, at the very least, there would need to be a trial about that, about what was intended. The third thing that I mentioned is, or maybe the second, is the timing of the suit. Did Mr. Mayberry miss the 6-month limitation period, if there is one? There is some discussion in the appellant's brief about how the termination was, or implied that the termination was in June of 2020, because he left the office and never came back. And I would refer the court to 2 things on that. One is the Lamely email that's referred to as supportive of the idea that he was terminated in 2020 was written in August of 2020. That's the appellant's appendix 122. And to it is attached, just like the appellee's brief says, a July 27th, 2020 letter that says employment termination. Dear Ty, this letter will serve as official notification. You're out of here. That's at appellant's appendix 124. And appellant's appendix 108 and 109 is Mr. Mayberry's deposition testimony. Did you quit your job? I did not. This is in reference to 2020. What job were you doing if you didn't quit your job? Answer, I was continuing to call on business and prospect for new clients to help AWP. And this was in June of 2020, bottom of page 229 of his deposition transcript, appendix 108. So the implication that he quit, left, he was fired or something, that the termination occurred in June of 2020 is false. It did not occur. Certainly not as a matter of law, because we've got sworn deposition testimony that says I did not quit in June of 2020. And there's no reason for him to sue at this time. I mean, he's working on the relationship. We've got the emails between him and Jill Mulder, the company's attorney, referencing them working together in March of 2020. There's a claim that he should have sued, that the claim accrued, if you will, in March of 2020. Should have known they weren't paying him according to the 2019 agreement. Should have known at that point in time all the elements of a cause of action were present. So that's when the claim accrued. And so he didn't get his suit filed within 6 months of March of 2020. Well, he's still employed until July. He's still trying to figure out who is in charge. He's still trying to figure out, are they going to make this right or are they not? Is this just a bump in the road or not? What he didn't know was that Mr. Rowe had said in 2020, we need to get this guy out of here. And again, the Mulder emails are on our appendix, starting at page 297.
What about the email? What about the email in May of 2020 from Rowe that advised your client that Acrisure Wall Street would not be recognizing the backdated amendment to the employment agreement?
Well, yeah, I mean, there a couple of things about that. It's not clear that Rowe is in charge. It's not clear that Rowe has authority to make that statement at that time. And secondly, the backdated portion, to the extent that this is a complaint about a backdated amendment, like you guys cooked this up, you and Mr. Wilbur cooked this up, there's metadata evidence that proves that that's not true.
Well, that doesn't, whether it's true or not, it appears Mr. Rowe in mid-May of 2020 made very clear that they would not be recognizing, whether it's a backdated amendment or not, they wouldn't be recognizing the amendment as valid.
All I can
Did they
say,
ever pay him the amount in the?
no, no, all I can say, Judge Swartzel, is, I'd rather have, this is not the strongest argument we have. I mean, I acknowledge that. I'm not going to stand here and say this is just as.
Your better shot is getting,
Yeah.
is not recognizing the 6 month.
But I will say that I think to say that as a matter of law, he had all of this in place and could have filed a lawsuit sooner than he did. I don't think, I think that would be a stretch. I mean, he's the Mulder
You're
emails.
suggesting there's a question of fact on.
Yeah, I mean,
Okay.
and in light, especially in light of the fact that they were trying to, Acrissure's, no, this is on the plaintiff's appendix, page 72. At the same time, he's negotiating with Jill Mulder about the terms and conditions of his employment, and she's drafted an addendum or an amendment to the employment agreement that has exactly the same stuff in it that, we claim should be there now, except that it's got an at-will termination provision. At that time in March of 2020, literally within 2 days of her email to him, there's the email from Mr. Rowe to the other guys at Wall Street Group saying Ty Mayberry's going through all the employees, and he says may want to stay, but we should help leave. I mean, they're actively trying to get rid of him at that time. From where we stand now, yeah, maybe that was a breach, but from where he was then, he had no idea that was going on. What he thought was going on is he was working with the company lawyer, going to put this together. Everything's going to be fine. Everything's in flux. There's a lot of backbiting.
Right, but I
stuff
mean, I
going
think
on.
you recognize this is not your strongest argument.
recognize
and
that.
At best, there's a question of fact on whether the 6 month was made.
Yes.
Okay.
And then the last thing, of course, is the Rayford case. And this case, there's been some appellant has taken a position, well, you never brought that up in the trial court. Well, Rayford didn't exist at the time that we were in the trial court. I mean, you can make arguments about whether or not this is a reasonable limitations period, but given the state of the law at that time, would have been.
We're not going to ignore Rayford.
Okay. That's good to hear. Just a few highlights from Rayford that I think are.
We've read Rayford.
Okay.
We're good.
All right. You don't want me to, okay, then I will not. I think what I'll say about that then at the end, my argument about it is whether 6 months is reasonable, given all of the knocks on the 6 month idea that appear in Rayford, and there are a lot of them, that employment agreement, I'm doing what you told me not to do. And I acknowledge it. Employment agreements are special. They're different from other types of agreements, and 6 months might not be a good, I mean, that's definitely implicit in Rayford. Whether the 6 months in this case is reasonable, given all the concerns that the Supreme Court expressed in that case, I think it's got fact issue written all over it. It cannot possibly be.
The Court of Appeals, we're all dealing with Rayford issues on remand. This is one, case that you don't need to belabor. Trust me, we are well aware.
Thank you.
Of all the implications of Rayford.
I think that's, pretty much the highlights of what I wanted to discuss. Unless the court has any questions, this is my last chance to talk to you. So please hit me up if you got something.
I think we're good. Thank you.
Thank you so much. Again, good to see all of you. Last time Judge Maldonado was in the old GM building and it was 90 degrees outside. How things have changed.
Not 90 degrees anymore. You have time for a brief rebuttal.
Thank you, Your Honor. Do you know how much time I have?
I'll cut you off when.
Okay, please do. Thank you. I'll just say, first of all, that the Rayford issue is waived. There's no reason for remand. That issue that's water under the bridge. The argument that there's no evidence that this application is for AWP is wrong. I've given you 3 pieces of evidence. 1, his admission in the deposition. 2, the letter that he got contemporaneously with it that said this is for the employment we're talking about, this application. Okay. And then there's, of course, the circumstances that they were handed together, which is evident from the letter that he received. The case law says that when you get documents like this together, you read them together to determine what the party's intent is. That's what the case law says, and that's what this court should do. read them together to determine what the party's intent. It is counterfactual to think that an employer would hand and the employee would understand that they're handing me these documents, they're saying they're both for my employment, but this one knocks out that one. Terms in this one don't apply because there's this integration clause in this other one. Simply not intuitive at all, and it's not what the parties intended. And I don't think that intent can be gleaned from either the circumstances or when you read these documents together as applying to this, concerning the same employment with AWP. And I don't think that they can have it both ways. If these are conditions of employment, okay, then this is all one employment agreement. This document is part of the employment agreement. If it's a condition of employment, that's the only way to understand it, not only because the letter says so, but because they were handed to them at the same time.
There's an integration clause which would cut against that. But if they're both employment agreements, I just don't think that that would work.
They are one agreement. They're not both employment agreements. They're one agreement. According to the case law, it's one agreement. We've cited that in our brief. We discussed.
The case law deals with cases that either don't have integration clauses or they have an integration clause but cross-reference the other agreement. There's nothing that has an integration clause and doesn't cross-reference. So you lose me there.
Well, a cross-reference is an indication that they were understood to be read together. So is a letter that you get later that says these both apply.
So the letter outside of the agreement should be read the same as a cross-reference within the agreement?
Absolutely.
Okay.
And in fact, if you want to consider it a subsequent amendment, consider it that. But
Subsequent amendment would have to expressly reference and purport to modify the employment agreement per the terms of this agreement.
Right. I don't think you can say it's an amendment because it doesn't follow the amendment process.
You have to cross-reference it and purport to modify it per this agreement. That's what it says.
Well, but the letter was.
A letter that just references that a letter would have to meet those terms to modify it. You couldn't be one-sided, couldn't not reference it.
Right.
You could have a subsequent employment agreement altogether. We probably won't even look at it because it doesn't purport to modify this or cross-reference it.
Well, ultimately,
You could sign the employment application second. It wouldn't matter to me.
Ultimately, the question is, what is the intent of the parties?
We do that reading the terms of the contract, which has an express integration clause, and that's the intent. We don't look at parole evidence unless there's ambiguity. I don't see any ambiguity in a very express integration clause.
If there was ambiguity, it would go against the drafter.
Well, I mean, first of all,
I think in future contracts, you may want to cross-reference the employment application or modify the terms to include it. Otherwise, that's just the result of the contract that the employer provided in this situation.
then if it's not part of one agreement, then it's not an employment agreement because he doesn't wind up being employed by it. That's our position.
Okay.
As for when the breach occurred, his claim is for not being paid under the terms of that agreement. And the first time he wasn't paid was in March.
Okay.
Thank you.
Anything else?
Any other questions for me? Any other questions?
No questions.
No, thank you.
Thank you.
Thank you so much for your time.
Thank you.
That case is submitted. Moving on to the 24th matter of our case call, In re Havel. It's docket number, 376549, In re Havel.
Good morning, Court. Lori Longo on behalf of the appellant.
Hello, Ms. Longo. You may proceed.
The facts of this case are very simple and have been addressed in the brief in detail. If the court would like, I can jump to the primary issue, which is which version of the waiver factors applies.
Please do. Please jump to the legal argument you want to make.
Okay. Okay. This court and the Michigan Supreme Court have consistently held that the waiver factors, unlike the rest of the juvenile code, the waiver factors specifically are procedural and not substantive. Because they're procedural, the Michigan Supreme Court is the only body with authority per our Constitution to enact them and to amend them.
Ma'am?
Yes?
What is your case that says that the waiver factors of MCR 3.950 are procedural and not substantive?
If you turn to page 15 of my brief, it gives you the cases. And
I just need the one case that says precisely that MCR 3.950 waiver factors or MCL 712A.4 waiver factors, which are the same.
People
Those are
versus
procedural.
Jackson, for this court, People versus Jackson, which is 46 Mich. App 764 at page 768, citing Perrin v. Puller, 373 Michigan 531. And what Jackson says, and I believe you cited Jackson 2 years ago, Judge Schwartzley. So
Pretty sure I don't remember that.
It's still good law. What it says, and I quote it in the brief, and what I should have done is underline it, highlight it, and made the text 3 fonts larger, because it really is pivotal language. It says the exception to exclusion jurisdiction in juvenile court is given effect by reference to the juvenile court rules. It's saying that it's the court rules, not the statute, that control, and that's because they're procedural. The whole quote is, when the Supreme Court in 1969 undertook to write the juvenile court rules, it assumed its power to govern the rules of practice, procedure, and evidence. Accordingly, the exception to exclusive jurisdiction in the juvenile court is given effect by reference to the court rule, which, as well as other general court rules, have the force of law. That's Jackson. Now, in Peters, the Michigan Supreme Court also emphasized that it's procedural, not substantive, that the waiver factors are procedural, not substantive. And that's because it's governing the decision-making process by the trial court judge. And it's different than, for example, this court has an unpublished opinion, a recent one, Patterson, which I did not mention, first of all, because it's unpublished, but also because it doesn't deal with the waiver factors. It deals with the existence of jurisdiction from the get-go, which is not something that requires a judicial decision or the process of decision-making by the court. The waiver factors, on the other hand, once you have jurisdiction, the court has to actively make a decision to waive it. And it's this making of that decision, this process of making this decision, that the waiver factors were created to guide. And in Peters, the court says that that's what they're for, and that's why it's procedural and not substantive.
So Ms. Longo, if we decide that these are rather substantive rather than procedural, do you have a backup argument do you still win regardless of whether we consider them substantive or procedural?
I think we win either way.
Okay, well then why don't you, because whether they're substantive or procedural is an interesting legal question, but if you win both ways, why don't you just tell us why you should win regardless of our answer?
Well, here's why it matters, because if it's, let me explain, if you don't mind, if I could take a moment and explain why that matters so much. Because if it's procedural, the amended version of the waiver factors apply.
No, I know. We're aware of that, but I thought you just said regardless of whether we treat it as substantive procedural and whether the amendments apply or not, you would win. And so am I wrong?
I think it's a much harder win much harder when, if the old version applies, because it focuses on adequacy of the punishment, which was something that was abandoned with the new amendments.
Well, let's move it from punishment to, I forget the language. It was, rehabilitation, services that would maybe help this young man. So if it's certainly punishment in one respect, but you could say, well, there are going to be services available in the adult court that are not available in the juvenile court. So set aside punishment. Why was the judge's decision here wrong?
The judge's decision was wrong for multiple reasons. First of all, her recitation of the facts was not an accurate representation of the facts. But more importantly, her emphasis on the 15-year sentence available in the adult court, her repeated focus on that. I think she referenced it 5 times and specifically discounted factors because of that and discounted evidence because of that. Now, when you are using that as your guiding principle, well, there's a 15-year sentence in the adult court and that's what matters. That's not what either version of the waiver factors provides. What that really does is convert this traditional waiver into an automatic waiver. Now, the legislature could have said that if you have a negligent homicide by drunk driving, that's an automatic waiver, but they did not do that. And by tying the analysis to this 15-year sentence and saying nothing is going to be good enough except this 15-year sentence, the court was turning it into an automatic waiver and interjecting that crime into the list of crimes that the legislature, for which the legislature had determined an automatic waiver was justifiable.
Okay. Any other questions, Judge Maldonado? Judge
No,
Ackerman?
I think it was briefed well.
Okay. Thank you. This is a difficult case and, as Judge Maldonado indicated, it was briefed very well and we appreciate that in a case like this. That's very helpful to us. So thank you for your time and the case is submitted.
Thank you. Thank you.
Thank you. Calling the next matter on our docket for this month. Docket number 368218, In re Mitchell N. Bunker and Linda K. Bunker Trust. We have oral argument that has been preserved for the appellee. The appellant who is representing her is acting pro per, has been permitted to attend for questions only. Do we have either or both of these people? Neither of them are in the waiting room? Okay. This was set.
There's a 26 case, maybe.
What's that?
I think there's one.
Yeah. Well, I'm just, so I want to make clear, case number 25, docket 368218 was part of our 11 o'clock case call. It is now 12:42. It appears that neither of those who had
panel.
Yes.
I believe both are are appearing remotely and have been moved over to appear
good.
Before you.
All right. Well, then let's go forward. Mr. Losnack.
Good afternoon, Your Honor.
You appear to be in a very dark place. We can barely see you.
Can I move over a little bit? Helps?
Yeah, my guess is it's the window behind you that's
Yeah.
causing some issues. Do we have Ms. Bunker, who was permitted to appear for questions only?
Yes, I'm present.
Okay. Do you have your camera on, please?
I'm working.
Okay.
It's showing me, but my here it is. There I am.
Okay.
Sorry about that.
No worries. Ms. Bunker, you are the appellant. You are appearing for questions only. So I'm going to start with you and I'm going to ask Judge Maldonado or Judge Ackerman. Do you have any questions at the outset? Okay. So let's hear from Mr. Losnack. And then if we have any questions after Mr. Losnack, we can ask those of you, Ms. Bunker. But before I do that, Ms. Bunker, would you mind putting your name on the record, please?
Dixie L. Bunker.
On behalf.
On behalf as a successor trustee for the Mitchell and Linda Bunker Trust.
Great, thank you. Mr. Losnack, would you make your appearance and then you may proceed?
Good afternoon, Your Honor. Daniel Losnick on behalf of Randall Bunker, one of the beneficiaries of the trust. I intend to be real brief here. I know it's been a long day. I've been watching since 11 o'clock, and I see your minds have been working pretty hard all morning. Couple things I want to bring up. This was an in pro per brief. I had a hard time figuring out what exactly was the issues. So I'm here to answer any questions about my presentation to those answers. Since this was an arbitration, there's limited review by this court. The review is as to was there an error of law that would have made a different conclusion obtained on this case. The arbitrator, Mr. Banner, explained his rationale in his opinion. He cited cases. All are well in good standing currently in the law. So I don't see any issue that would be subject to having this arbitration ruling overturned. The only issue that I could see that had any substance was that Ms. Bunker was alleging that she didn't have a right to go to a hearing. The arbitration rules are very diverse in that they give you lots of options. One of the options available is that the hearing can be bifurcated. The bifurcation in this case occurred by agreement of both myself and Mrs. Bunker's attorney, Stuyven Reich at that time. We agreed that since the deeds had a bunch of problems on their face, that the arbitrator should make a decision as to the validity of the deeds, maybe resolve the case. Both parties agreed to that. Those issues were submitted. The arbitrator was able to resolve the case based upon the deeds themselves.
Mr. Losnack, I don't mean to cut you off, but I mean, this was pretty well explained in your brief.
Yeah. And so, I mean, basically the only thing that, as far as a legal issue goes, was can a trust create a life estate? I mean, there's no case law in Michigan that deals with trust itself. It deals with joint tenancy, meaning a trust cannot be a joint tenant with a person because the life cannot be measured. But that's the only case that only issue that I could see that this court would have a chance to expound upon and resolve, make it clear for the law that trust cannot do ladybird deeds, basically. Okay. So, I mean, that's anything else, ask me. I'll try to explain what I can if you have questions.
Any questions, Judge Maldonado?
No, thank you, Judge.
Judge Ackerman?
No questions.
Okay, we have no more questions for you,
Thank
Mr.
you.
Losnack. Any questions for Ms. Bunker?
No.
No. No questions for Ms. Bunker. We appreciate the briefing in this case, and we will do our best to get an expeditious decision out. And we thank you for appearing.
Thank you.
The case is submitted. Moving on to the last matter for this month. The 26th matter, docket number 374947, People v. Mabry. Ms. Barbier was endorsed. I don't see, there's no one else in the courtroom. There was no question, or at least that I'm aware of, request for Zoom. I will wait a few seconds that if somebody in IT tells me that there's someone waiting, then we'll take up the case, but otherwise.
Nobody waiting.
All right, that case is submitted on the briefs, and that ends our February 2026 Grand Rapids case call.